This meeting is being recorded.
Good evening. Welcome. As people begin to come in, we will start momentarily. I'm just going to give it a few minutes to allow everyone to join us. Good evening. Good evening. If you're just coming in, welcome. We're going to get started in a few moments. I'm going to give it 1 or 2 more minutes just to allow people to come in, and then we will start. Thank you. All right, well, we have a bit to cover and we're supposed to start at 6 o'clock today. So why don't we get started? Good evening, and thank you for attending today's fireside chat, ADR in Corporations, Thoughts from the Top. For those that do not know me, my name is Lauren Jones, and I have the distinct honor to serve as moderator for this evening's event. I'm so excited and privileged to be sitting down with the General Counsel and Head of Litigation for Duke Energy. Not only is Duke Energy a Fortune 150 company, but is also closely related to my alma mater, Duke University. Go Duke. Tonight, though, we are here to discuss ADR, that is alternative dispute resolution, and how it is viewed and used by corporations, and specifically how we can diversify the selection of neutrals used by large corporations. Before we get underway, I want to thank the Metropolitan Black Bar Association for its unwavering support to the ADR section and our mission of increasing diversity in the ADR profession and propelling our neutrals forward. Myself, along with my co-chair, Jill Pilgrim, are very proud of our section, which has made it a focus not only to help train more mediators and arbitrators, but also of color, but also to work for all diverse neutrals of color to increase the opportunities for us to get hired and succeed. So it was extremely exciting when Kojo Gardi Taco and Vijay Bandada agreed to speak to our section and members of the ADR community at large about increasing diversity in the ADR space. Therefore, a very special thank you to you, gentlemen, for stepping up to the plate to talk about this very important topic. Also, a special thank you to our co-sponsors for tonight's event, the South Asian Bar Association of New York, which, as you will hear, holds a special place for one of our speakers tonight, the National Bar Association's ADR section, and the New York State Bar Association's Dispute Resolution Section's Diversity Committee. Say that 3 times fast. As for some housekeeping, we invite you to participate in this discussion and ask questions. This chat is for you, and we really want you to get all that you may want out of it. So in order for that to happen, we ask that you keep your questions in mind and write them down as they come to you in the chat. I will ask as many questions as I can at the end of this program, and we have specifically reserved about 15 or 20 minutes at the end. So hopefully we will get to as many questions as we can. Don't be shy, please. Now, without further ado, please allow me to introduce you to our panelists. I will start with alphabetically. So I'm going to start with Vijay Bandada. Mr. Bandada is a vice president of litigation for Duke Energy. He is responsible for overseeing all of the company's litigation activities. Vijay joined Duke Energy in December of 2016 from Pfizer in New York City. He served Pfizer as vice president and assistant general counsel, litigation, and corporate risk management. As a member of the litigation leadership team, Vijay was responsible for managing several of Pfizer's key litigation matters across the United States and Canada. In addition, he managed a team responsible for global risk management and the administration of all global insurance programs and insurance-related claims. Vijay is no stranger to the country's premier law firms, having worked at both Skadden Arps and Reed Smith. Vijay also has a strong connection to New York and one of our co-sponsoring organizations, having served as former president and co-founder of the National South Asian Bar Association, now known as SABANA, also as a former president of the South Asian Bar Association of New York. Thank you for joining us, Vijay.
Thank you.
And Kojo Gartitago serves as executive vice president, chief legal officer, and corporate secretary for Duke Energy. He is the primary legal advisor to Duke Energy's board of directors and senior management, and he leads the office of the general counsel, which includes the company's legal, corporate governance, internal audit, and ethics and compliance functions. It's a big job there. Prior to being named chief legal officer in October 2019 and corporate secretary in May 2020, Kojo served as president of Duke Energy's utility operations in South Carolina. Kojo joined Duke Energy in 2002 as chief regulatory counsel for Duke Power. And he had numerous positions in the legal department covering several areas of legal service to Duke Energy. He served as Duke Energy's senior vice president of state and federal regulatory legal support, general counsel for litigation, and vice president for legal for Duke Energy's commercial business organization. He also served as vice president, legal state regulation for Duke Energy's franchised electric and gas business. And before joining the company, Kojo was a partner with McGuire Woods LLP in Virginia. Okay, so now we know who we are privileged to have before us, and you will probably see why I'm so excited to hear from them. So we'll just kick it off. I think many of us, myself for sure, is very proud to see the diversity in the top 2 lawyers at such a large corporation. Even in 2022, we know this is not a common sight. And this is something that each of the sponsoring organizations here tonight work very hard to change. So before we dive into the conversation about ADR, there are many lawyers here today, many diverse lawyers who strive to accomplish where you both sit. Can you tell us a bit about your career journeys and paths? Kojo, let's start with you. How did you become to get to be the general counsel of a large corporation such as Duke Energy?
Well, Lauren, thank you very much. First, I want to thank you and the various sponsoring organizations for this opportunity for Vijay and I to talk about Duke Energy and how we manage litigation. Talk a little bit about ourselves too. Thank you very much for the opportunity. How did I get to be general counsel? I would say by the grace of God, because if you look into my background, my past, I'm not sure that I was born, if you've taken a poll of my middle school classmates, high school classmates, college classmates, or even law school classmates, that anyone would have said most likely to be general counsel. But here I am, here I sit. I went to Duke University like you did. I went to law school, and I'm originally from Ghana, West Africa. And the plan was I'd get a law degree, work for a couple of years, and then go back to Ghana and join the foreign service of Ghana. I wanted to be a diplomat. And one of the classes I took in law school was labor relations, and the professor offered a luncheon to anyone who would call him if they were ever in his city. And so I ended up in DC and called him. And he took me and a friend to lunch. And when he heard my plans, he said, "No, you've got to stay in this country. Next thing I know, he's introducing me to the immigration lawyer in his office. Next thing I know, I'm on a path to staying in the country. Clearly not just because he said so, but he actually forced me to think some more about my choices and what I was planning to do. And, I ended up with a law firm in Washington, D.C. that focused on public utility regulation. This was not something I had learned in law school. It just happened to be the first job I got, and I took it. So I worked there for 6 years and then left D.C. and moved to Richmond, Virginia, and worked for a firm there for 6 years, also in the public utility space and commercial litigation generally. And then I moved across the street to another firm, McGuire Woods, which was the one you mentioned when you talked about my bio. In the last two firms at Richmond, Duke Energy was a client, a relatively small client, I might add. One of my senior partners had been an in-house counsel at Duke and had maintained the relationships after he left. So we would come make pitches for new work, or they wanted to hear about energy deregulation, something that was hot and heavy in Virginia and was being considered in the Carolinas. So we would present on that. After one of those visits, one of the in-house counsels reached out to me and asked if I'd want to come in-house. And I initially said no. The next year he called me again. And this time I said, let me think about it. And I went through an interview process and joined the company in June of 2002. So this coming June will be my 20th anniversary. And it's been a wild ride. As you noted in my bio, I have served in virtually all the legal departments here at Duke. I started in regulatory, I left, went to litigation, I came back to regulatory. Left, went to support our commercial business, doing transactional work, came back to regulatory. Then I went into the business for a few years, and then I got called back for this position. It is a position that I always thought of as a dream job, so I was very excited to be asked to come back to it. It's a very challenging position. I'm not sure I thought very much about it all those days when I said I wanted to be general counsel. But no one day is alike. It's a very exciting position to be in, getting to interact with the senior management team, getting to interact with the board of directors, being aware of every legal issue that we're involved in, and getting a say in how those legal issues get resolved, get discussed as a client, as well as a support to our clients. So that's how I got to be where I am today. And I'll let VJ respond to how he got to be where he is.
Awesome. Before we hear from VJ, I mean, I think there were some really key takeaways from how you got where you are, right? First, obviously, grace of God. I think, everyone could look back and point to something that, serendipitous or not, it happened, right? Networking, that seems to be a really big theme in your success story. Not only networking with clients, but also networking with friends, colleagues. And when they suggest calling you and reaching out, you actually did that, right? A lot of people get that invitation, call me if you're in town, call me if you ever want to talk. And they think they're just saying it and no one takes them up on it, but you did. And that opened the doors for you to have your career. Also trying something new, being open to new ideas. That's something that's really, I think, it sounds like it was crucial for you. And I think that's something that a lot of lawyers particularly get so myopic and where they think they want to be and what area they want to practice in, that they get very closed-minded and don't realize if they take a step outside their comfort zone, look what can happen. Relocating, being willing to relocate. That is something that's for New Yorkers, especially. That's a very sensitive topic. But you were getting ready to go back to Ghana and found yourself in DC. So that certainly is, again, open-minded. And also heard something that sounded like being an expert in a field that allowed you to prove your value, doing presentations for former clients and really seeing how much you can add to them. Sound like that was a big help. And finally, be careful for what you dream and you ask for, because you may get it. And you may be unaware of all of the nuances that come with it. Heavy the head. But congratulations to you. What a journey. We're proud to see you there, for sure.
Thank you. Thank you very much. I think I'll call you when I get ready to write my book. You summed it up very nicely.
Okay, Vijay, your turn.
Lauren, thank you again on in the same message as Kojo. Thank you for inviting me to speak to the both bar associations, the MBBA and Salvini, organizations that I'm very fond of. I've had many friends and colleagues over the years that have been very active in both organizations. It's a delight and an honor to get to speak to both of these bar associations and their members. I think the first thing I wanted to point out, and I think you alluded to this, is it's a very unique situation at Duke Energy, and especially our legal department. Like Kojo, I am also an immigrant. My parents, I was born in India. My parents moved in '69, so my father could pursue his education in Philadelphia. And I came over when I was 2 years old. And like Kojo, I probably was not somebody who was thinking about a career in law and was being sort of groomed and pushed towards medicine all my life, and then realized that I had no interest in practicing medicine. And I still remember to this day my father saying to me as well, why would anyone go to see you? You're an Indian lawyer. and so by the grace of God, somehow I managed to get to where I am as well. So I will say I grew up in Pennsylvania, central PA, where back in the 70s, I can tell you there was not much diversity in small town Pennsylvania. After growing up there, I went to school at the University of Miami, Florida, primarily because my father still thought it had a great medical program. So that's how I ended up there, but then realized I wanted to go and be a trial lawyer. So I came back to Pennsylvania to go to Temple and graduated from their trial advocacy program and focusing on litigation. And after spending a few years at Reed Smith in Philadelphia, at the end of '99, I moved because I came into contact with Skadden Arps, which was co-counsel on a major piece of mass tort litigation. And they reached out to me to see if I was interested in moving to them. And I made the move from Philadelphia to New York at that time. And then after practicing at Skadden for a number of years, and I was doing more and more work for Pfizer, I found myself gradually, I had to reach out by Pfizer saying, would I be interested in coming in to help manage a book of their business there? And primarily product liability, commercial litigation, and insurance litigation as well. So I went into Pfizer at that time in 2007, and then also moved, as you said in your biography, over to, and I was actually working for Sandra Phillips, who was very active in corporate counsel Women of Color, and was my boss and the head of litigation, and now over a general counsel over at Toyota. And so she played a central role in she had left Pfizer, and 2016 rolled around, and Duke was looking for a new head of litigation. She was played a central role in picking up the phone and calling and talking to folks at on Duke's search to put my name forward, and that's how I got to know the folks over at Duke, and frankly, just the challenges and the team and the type of leadership that Duke has made it a very compelling reason for me to pick up and leave New York. As you said, it's never easy for New Yorkers to leave New York, but frankly, it is a company that I have been delighted to get to know, and an industry that was completely new to me and very, very complex, but comes with a openness and a charm and a willingness to change, and it's in high transformation, so it made it really interesting. And then it has been over the last several years, I've had a chance to work directly with Kojo as he's come into this role. So one thing that he hasn't mentioned among his many roles that he has done, even prior to me getting here, is Kojo has been a pretty prominent champion for DE&I early on in our legal division. And so he's one of the earliest chairs of D&I at Duke Energy. So it's really great to have him in that role, and for us to be now moving the needle forward on so many areas.
Awesome. Thank you, VJ. And obviously takeaways from your story as well. I hear you following your own dream instead of what somebody else, has a vision for your life. I think that's really important. Sometimes people, especially diverse lawyers, sometimes tend to live out what their family wants them to do or what their friends want them to do. And really, it is a good reminder that we're living our lives for us. And also you had, it seems like a very good foundation for your litigation career. You had a lot of preparation, being at 2 firms, doing trial ad. You kind of seemed like you always knew perhaps litigation, but maybe not the exact subject matter. And so that's kind of interesting to see as well. And also networking. I mean, that's always a big theme, right? Networking. If you see attendees, I've put in, I hope Vijay and Kojo don't mind, I've put it, but public information, I've put in their LinkedIn links. So, connect, right? This is what this is all about. It's all about building connections. You see somebody sometime, introduce yourself. That's kind of the name of the game. It worked for these gentlemen, and watching it work for everybody else. So exciting to hear your stories, inspirational. Now we can get a little bit closer to where we are headed, which is about ADR. But before we jump in there, I think a natural connection is what Vijay kind of alluded to. Kojo, you are a champion of diversity, equity, and inclusion. And you as general counsel presumably drive much of the policy and philosophy behind Duke Energy. So can you tell us about Duke's philosophy on diversity? How does it score? How does it move the diversity needle? And what changes have you implemented since you've come on board?
Well, thank you. Thank you very much for that question. Duke Energy's philosophy on this topic is one of, let me start with the Office of General Counsel, and I'll talk more broadly about the corporation. But in the Office of General Counsel, we firmly believe that when you have a diverse team assessing an issue or a problem, you tend to come up with the best results, right? So number one, for me, it is not some altruistic endeavor here. It is my quest to provide the best possible solutions for very complex problems that we have here at Duke Energy for our clients. And if I have the opportunity to get the best possible advice, why not? Why leave some players off the field when all the putting an entire team on the field will get you the best results? So that's the way I come at this. And I think there are plenty of studies that show that. I'm actually very tired of talking to the merits of diversity and inclusion. It is well settled as far as I'm concerned. There's some who want to hear it's the right thing to do, and that's why they're doing it. That's fine. And we want to do the right thing too. But we absolutely want to get the best possible results. And that's why we do what we do. And it starts with looking at yourself. If I don't have the best team internally, and as far as I'm concerned, the best team is a diverse team. If I don't have that internally, how can I ask that of those who support me, the law firms, and the other consultants that we work with? So we're very focused on building a diverse team here at Duke. We're very focused on demanding that our outside firms also present us with diverse teams. And here we're not talking about people who show up for presentations and never bill any hours. So we not only put out these expectations that they not only form teams that are diverse, but they actually have diverse teams doing the work. And we track this. We track it in how much time they bill to us. We track it in how much money they charge to us. We actually track the opportunity to hire minority and other diverse owned firms. So we're not just talking about majority firms like the firms that VJ worked with and how diverse the teams they bring to us are. But we're talking about firms that are actually owned by women, firms that are owned by veterans, firms that are owned by African Americans. And every year we set aside some money just to target those types of firms, right? So we have internal goals that VJ is compensated on, that all of our lawyers are compensated on. If we don't hit those goals, they don't get paid as much as they otherwise could make, right? And so that's how we ensure that we meet these goals that we've set for ourselves. Because, I mean, It was quite an eye-opener years ago. I think this was in 2005 or so. Our general counsel was, at the time, was invited to a D&I conference in Washington, couldn't go and sent me. And one of the things I came away with was a statement from a managing partner of a well-known DC firm, who basically said, my partners will not do anything different until you, the in-house counsels, make us do it. And that's been my mantra since that day. I want to do everything I can to make them do it, right? And so we have conversations constantly about their efforts. And there were times when we actually would grade our firms on an A to F scale. And if you failed, we called you in and we gave you tips on how to do better. And if you consistently failed, we went somewhere else with our business. Because then it told us you are not committed, you're not working hard enough to give us the best possible team to do our work. That's our philosophy. On an enterprise-wide, we serve a very diverse community in 7 states for electric service, 8 if you count gas, 1 gas state where we don't serve electricity. All our customers are diverse. There was actually a time when we had a huge hurricane here in the Carolinas, and the lights went out and customers were calling in, and many of them spoke only Spanish. And unfortunately, we didn't have enough people who spoke Spanish to take their calls. And since then, we've been on a mission to diversify even our call centers, our line workers, our office workers, accountants, all our groups are on a mission to provide to have a diverse workforce. We're not where we need to be. We're not where we want to be. And this is a matter that comes up to the senior management team on a regular basis. We look at the numbers and we challenge each other on how to change things that need to be changed. And we want to push ahead to have a diverse company that is a place where everybody wants to come to work and everybody wants to come enjoy working when they come to.
Extremely exciting to hear. I mean, preaching to the choir, right? You obviously understand and appreciate the value and the need for DEI more than just the business case, the practical real world. People are different. You need people that can speak little different languages, literally, but also different life experience that can bring different perspectives to the table. So, I mean, that's you hit the nail on the head, right? And I love that diverse team equals best results. And what we're going to talk about a little bit more, right, is that diverse teams, specifically diverse legal teams, are comprised of many different components, right? We're not just necessarily talking about lawyers that work on cases that comprise of one's legal team, but the acceptance and realization from Duke Energy, led by you, that the need for diverse teams by corporations is necessary, especially in 2020, moving on to, for the future, is required. And that helps you get the best results. Vijay, do you have anything else you want to add to this point?
No, I think Koja has really summed it up well. His point on the fact that we do set targets and goals, not just lower in the organization, but every executive within the organization, all of Kojo's direct reports. I just want to punctuate that. We have set goals that we're measured on. And these goals are not, we revisit them constantly. In fact, we're in the process of revisiting our targets right now. These are not meant to be layups. These are meant to be stretch goals. And we consciously work to stretch ourselves, to make ourselves better. And I think, we'll talk more about that. I think that dialogue here today is part of our, Duke's own internal, the spirit of continuous improvement. Always looking on how to achieve even more diversity in the way that we operate.
Not for nothing, financial motivation is probably the best motivator, right? I mean, for your internal team to hit their goals, and also for your external team, right? For the lawyers, if they're not bringing you what you're asking for, which is the diverse team being used broadly, then you're not going to hire them. Presumably, you're not going to give them the money, and they'll feel in their pockets, and that always has the bottom line. That always matters. And so what I'm hearing is there's a lot of intentionality with your actions, specifically as you're talking about outside counsel. So intentionality with litigation counsel is great. And I agree, as a former partner, I used to always tell my clients, you hold the power to demand diversity. Some did, some didn't. But it is clear that intentionality is something that is definitely required. And so I ask you, the same way you demand that your outside counsel be diverse, is that something that you currently demand with your arbitrators or your mediators, right? We're talking about this broad, diverse team. And I know that we've spoken about this before, but I'd love to kind of expound about that and speak about it now so we can talk about it and ask questions. Where do we stand? Where do you stand about ensuring and making that same intentional effort is put into the other part of the legal team that also plays a significant or can play a significant part in litigation? I'll turn that over to you.
Yeah, so Lauren, candidly, this is an area where we have work to do. I will not say that we don't have work to do here. It is not an area that we're not interested in doing work on. It has been our focus over the last several years to really intentionally move the needle on engagement of diverse lawyers who do our work, both internally. We've been working very diligently to build the ranks of our in-house teams with diversity and equity and inclusion, but also outside. We need to do more on the mediators and arbitrators. The challenge for us is frankly that we don't do a lot of arbitrations, and every company does it in a different way. I'm not saying every company has a different way it looks at ADR. For Duke and many in our sector, we prefer mediation over generally arbitration, at least in the litigation context. We do arbitrations in employment areas and certain key areas that are contractually required in some of our legacy areas. We have arbitrations, but generally we're not doing arbitrations. We do have mandatory mediations in many of our territories. So usually the process is that our law firms or consult with opposing counsel and come up with a panel and come back to us with a list of proposed mediators. That's where there's an opportunity that I look at. And I think this discussion is a good one, that we can actually try to move the needle on mediators that we use across a whole different matter. We use mediators, as I said, commercial arbitrations, personal injury arbitrations, property damage claims, where we have securities litigation issues, you name it, insurance claims. Mediators are very much a part of our fabric of what we do in litigation. So it's an area that we have used diverse candidates, but clearly we can use more.
And you spoke about it a little bit, but I'd like to kind of delve in a little bit more. How is Duke Energy currently selecting their arbitrators and mediators? I think you said law firms generally provide a list. Is that something that ultimately you select as the head of litigation? Does your team select it? Is it a combination of the two? And moreover, do you ever make recommendations to your outside counsel to say, hey, I encountered this person at a conference, why don't you give this person a chance? Talk to us a little bit about, because we do have a lot of neutrals here, right, that want to get hired. They want to understand what the top decision makers are thinking, what they're looking for in mediators.
So the decisions are made usually by the lawyers managing the matters in consultation with me. We do have a list of mediators who reach out to us and send us their credentials, and we put on our list. And I'll occasionally get emails from Kojo or other lawyers in the group saying this person has an interest in serving as a mediator. So we keep that list. Interestingly, it is not a very diverse list. We have not.
That was the next question.
We have not gotten a lot of reach outs from diverse neutrals. Where we've engaged a few. I will tell you that we do a lot of pre-litigation mediations as well. And these are usually in the context of very sensitive matters that we're trying to avoid a lengthy litigation. And in those contexts, we have used diverse mediators on occasion. But again, we have not gotten a lot of reach from diverse candidates, which I think hopefully we get more of.
And do you, especially now with COVID, and propelling forward, virtual mediations have been something that has now become kind of ingrained in the ADR fabric. Presumably the mediators and arbitrators that you now will be considering moving forward do not have to be based in North Carolina, is that correct?
Well, I will tell you, even before the pandemic, we were not limiting the engagement of mediators because they don't necessarily need to be licensed in our service territories. The key thing for us in selecting, and I think Kojo alluded to this as well, is really making sure we have somebody who doesn't need to be a subject matter expert, but is very good at listening, digesting facts, and then able to influence a resolution outside of court. And so that, to me, is sort of the litmus test of how we approach mediation. We want somebody who's actually going to be engaged, devote time to learning the subject matter of the dispute, and then being able to influence parties, whether it's us or our counterparties. But that's sort of there, but it doesn't need to be somebody in North Carolina or in our service territories in Florida. We have engaged mediators from all over the country on different disputes. And now with the virtual mediations, it's actually easier if we find qualified candidates to do it.
Because I think one thing people often wonder about is whether or not mediators and arbitrators need to be experts in the field or in the subject matter for which they're going to be presiding over, or whether being smart is good enough. Because oftentimes the lawyers are there to provide briefs if it's an arbitration, or if it's a mediation, they kind of can be there to help if needed with nuances of various subjects. And so that's something that's often discussed, I suppose, in the ADR world. The other thing that I, candidly would ask about, another problem that diverse mediators and arbitrators often express is the reality that the same people are getting hired over and over again. And those same people tend to be white males. And diverse neutrals often find that the system of selecting the neutrals makes it very difficult for someone new to break in. And so, as you just indicated, even the process by which Duke Energy used to use to select ADRs, maybe we'll be changing going forward, but allowing the lawyers, for the most part, to kind of produce these lists. If there's never any diversity within their selections, then there'll never be any diversity, right, that you get to kind of choose from or select from. So there are several bar associations, and there's going to be a question at the end of this, so feel free to respond to any of these comments also. A few of the bar associations, some of which have joined us today, namely the New York State Bar Association in conjunction with the New York City Bar Association, as well as the ADR section of the National Bar Association and others as well, have compiled lists, rosters of diverse mediators and arbitrators that stand at the ready, very smart, vetted, to be used by a company such as Duke Energy or any other large company that exists, or small or otherwise. Is that something that Duke Energy is willing to accept, consider for use in future cases? And yes, feel free to respond to that and anything I said just before that.
Well, unequivocally, yes, we would be open to looking at any list of diverse candidates. And obviously, there's, I do welcome the outreach from bar associations such as yourselves and NBA and others to say, how do we intentionally reach out to the general counsels and the litigation heads at various Fortune 100 and 150 companies like us and have that dialogue. We're easily available. I will actually be more than happy if somebody reaches out to me and says, can we incorporate it? I think that's something that we're always open to having a dialogue around. And it is something that we want to move the needle on. I will tell you, and Kojo knows this because he's my boss, it's in my goals to move the needle on I look at litigation as we are, just as the OGC is a leader at Duke Energy on diversity and inclusion, I look at the litigation team as being a leader within the OGC on moving the needle and how we engage counsel. So this is an area that we want to move the needle on. So I would welcome the outreach from many of the bar associations that you mentioned. I will tell you that as far as the perception of that the same people are appointed mediators always. That's probably not just a perception among diverse lawyers. I bet you it is a perception among anyone who feels, because I know for a fact that it's always the same list of mediators on especially large cases that I always see, that are always brought out. And so there is this sort of, oh, well, these are the people who've been doing it for the last 20 years, so why wouldn't I them? So there does need to be an intentionality and a dialogue around, really are, sort of underscoring the talent that's there within the diverse bench and making sure decision makers have those at their fingertips. And so knowing that if I have an antitrust matter or I have a very large, insurance recovery matter, that I know that it's not just these folks that have been doing it for the last 20 years, but there are other folks who have done it well for other companies or other disputes. And I think that's, it's not just, the onus should be not just on the companies, but even on the bar associations to help us get to that.
Yeah, I think we want to help. Certainly, I think dialogues like this, I think, are just the beginning. And candidly, there's even some mystification about who it is that makes the decisions at these big companies, right? Kojo, I reached out to you at first and I said, let's talk about how you select arbitrators and mediators. And you were like, me? That's not what I do. But generally, we sit in all these meetings. I'm on a number of boards that talk about, this is the goal that we talk about all the time, trying to see how we can get more diverse arbitrators and mediators selected by corporations and companies. How do we get to the users to, as you said, put down the metrics, make the demands on the lawyers, and everyone's sitting in the room and everyone's saying the GC, the GC, the GC. And the reality of it is, as I've learned and I'm speaking to you, is that the bar associations need help understanding who better to target, how better to effectuate the change. We have no problem using our voices, but we want to make sure that we're using our voices in the right way to the right audience. And so this conversation, I think, is very helpful dually, right? I think it's exposing an area of growth and opportunity for companies, but it's also helping us crystallize and better utilize our energy so that we all kind of working towards the same goal.
Yeah, so make no mistake though. So Lauren, make no mistake, the buck stops with me, right? But I don't make the day-to-day call on even choice of counsel. I do have plenty of influence. Make no mistake about that. But day-to-day, VJ, who heads up litigation, the folks who head up labor and employment, regulatory, they know they see the cases coming in every day. I don't, right? And so when the case comes in, an assessment is made. Do we need outside counsel? Do we not? If we need outside counsel, who do we go to? Who do we not? We've got a panel of firms we use. We did an RFP and selected them. And then we've got some niche firms we use depending on some specialty area. So everybody's required to use somebody on that list. And if you're not going to go to use someone on that list, I get to approve going outside the list, right? So we've got a structure in place that helps guide folks on which firms to use or not use. When it comes to ADR and arbitration and so forth, the attorney managing the case, I think VJ has explained this, also gets to weigh in. But if there's an issue and it bubbles up all the way to me, I definitely can weigh in, but there's sort of a lot going on, so I can't get involved in any one of those decisions. By the end of the day, let's say something goes bad and they say, gee, how did we get here? And someone says, well, they picked a bad arbitrator or something. Guess who the CEO is going to call? She's going to call me, right? So that's what I mean by the buck stops with me, but you can think of it as delegated authority. I trust my team to make the right choices, to do the proper vetting, and to identify who the appropriate mediator or arbitrator is.
Mm-hmm. And no doubt,
and sometimes too, I don't think VJ mentioned this. Sometimes the contracts actually spell out how arbitrators are picked, right? And so you've got to follow what that says. Mm-hmm. But I totally agree with VJ. This has not been an area of focus. I think your word of neutrals, for example, is sort of how I've thought about this. The arbitrators are the judges, right? And on some, I don't think of them as part of my team, right? And so all these models and ideas we've got about diversifying the team have not been extended to that. Because very often I don't have a choice in what judge I get. If I'm filing a claim, I do. I can pick my court, right? So I can factor that in. But when it comes to arbitration, VJ is right. I'll confess to this. We have not been intentional there. And so that is a growth opportunity for us, just as you've identified.
Great. Yeah. That's quite frankly, I think exciting to hear. And also, it is a good reminder that, of course, as the GC does, like if you have already explained, setting the overall philosophy and policy of the company, right? And so just same way that financial incentives have been kind of established for certain metrics within the diversity rubrics, it sounds like it could be within the purview to attach them also to, or expand it slightly to include ADR in that way, just as you're defining the team, I suppose. And so you mentioned, VJ, that arbitrations are not something that Duke Energy participates in a lot of, and everyone a lot could be different for everyone in terms of what that means. So can you tell us how many arbitrations has Duke Energy participated in, I don't know, last year or two, whatever number you feel you could say, versus mediations? And then how many of those, if any, and no one's judging you, right? Because we're all going up from here, but we can only tell how far we go up if we know where we stand, right? So how many of those do you think have been diverse?
So we have had one arbitration over the last 2 years. And that is in the civil litigation space that I'm talking about. It doesn't include employment arbitrations that happen through our labor and employment team, but ones that fall within my scope, we've had one. And then we've probably had about a dozen or so mediations that have happened, smaller cases, bigger cases, over the last 2 years. I will tell you, in those cases, the mediators have probably been diverse in 1 to 2 cases. One, an attorney of color, and the other one, a woman who was used. So clearly the numbers speak that there is a lot of room for growth in that area.
Okay. Let's see. I have been told this specifically, and I don't think I stand alone in being told this, because other members of our ADR section have also shared that they have been told this. It has been said that a known white male mediator or arbitrator could be chosen or would be chosen over, again, a new face, Black or brown or female mediator or arbitrator, because of fears that if the diverse mediator or arbitrator is selected and the case does not resolve or a bad result is reached, then the client may blame the selection of the diverse neutral. But if a white male gets the same results, it would be considered just a tough case. In other words, the performance and selection bar seems, arguably, for some, higher, much higher for Black and brown and women neutrals than their white peers. Any reactions to that?
Well, let me react, and then VJ can respond as well. Not in my world, right? I mean, we pick, and again, because in ADR, this has not been a focus, I can't speak so much on that. I will say, we always want to pick the best person for the role, whether it's ADR, whether it's lawyering on cases and all of that. We always want to pick the best person. And sure, if you get a bad result, we do a postmortem, and everybody should. And after action review, why did we get here? Or how did we get here? What could we have done differently? And if, as part of that analysis, we determined we picked the wrong law firm, it doesn't matter what racial background or ethnicity or gender they are. We picked the wrong law firm. And that becomes part of the evaluation to what you do the next time you have another opportunity to pick another law firm. And I can assure you, we have dropped law firms or not gone back to law firms that have nothing to do with race. or ethnicity. It has to do more with the performance and the outcomes, right? And I can assure you that in the ADR space, we'll approach it the same way. I'll let VJ speak to that, share his own thoughts on that.
So it's a cop-out. Is that what I'm hearing?
A cop-out? No, it's not a cop-out.
No, not you. I just meant the people that stand in the position to make this election to some extent. Let's say the law firms have said this, and they've been sometimes they've been Black men, quite frankly, that have said, oh, I'd love to, but I don't want to lose this client. But I'm hearing from the client that that's not,
well, I hope it's none of our law firms.
No,
that would be absolutely very disappointing to me. That would be it sort of suggests that white men can't screw up.
I agree.
I don't want to talk, a certain movie comes to mind right now. I don't want to go there, but it's just ridiculous. And I hope it's none of my law firms, because that would not be a good day.
And I have to say the same thing that Kojo says, we have parted ways with firms and lawyers, because one of my things is, more than the law firm, I hire lawyers. And there, obviously we have a select panel of law firms that we look to and niche firms, but within those niche firms and law firms, we're looking for lawyers, people who can actually solve complex disputes. And I will tell you that the results matter. And if people are not effective and they do not deliver a result, and litigation, by the way, is not always an easy result. We don't always win everything. And we do often come to difficult resolutions where both parties are not fully satisfied. And that, by the way, is the definition of a good settlement sometimes, that both parties are not satisfied. But we look to the lawyers. And so I have not seen any of our outside law firms say that. And I will tell you that it doesn't drive me, or I don't think any of the lawyers on my team, because it's very important to us that we try to engage diversity. I do think the law firms have historically brought us non-diverse solutions, but no one articulated to us that that's why they're doing it. I think they will usually put before us somebody and they will say, he or she has acted as a mediator on this many number of cases, and it looks like these are the solutions that they were able to drive at. And so that is very important for us to look at and say, hey, do they have familiarity with these kinds of disputes, this kind of industry, and the kinds of issues we're facing? And how do they operate? I will talk to other litigation chiefs oftentimes to just find out if a mediator is effective or not. So I hear that, but I also, and I think I said this, Lauren, before, is I've had that complaint come from even, white women or, white men who say, well, you always go back to this guy and you never give me a shot. And part of it is the industry tends to go to people who have had experience in this area. And I'm not saying that's right or wrong, but we need to be more willing to take a harder look at folks who deliver results that are down the pipeline as well. And so that's that I think we need to look at. So
Lauren, the problem seems to be one that most of us had coming out of school, right? You apply for a job and they say, oh, we need more experience. And we would all go home and complain, how do I get the experience if you don't hire me the first time? Mm-hmm. And I think that's the issue we're facing here. I think it's one of people being comfortable with people who've dealt with the same issue before, right? Sometimes if I have a bet the company type issue, it's not the one I want to try a new firm out on. And let's face it, that's not going to change. I'm going to go to somebody I've been in the foxhole with before. And I think the problem here is many times the people who have been in the foxhole with before, the people who have done these cases for us before, happen to be of a certain ethnicity, a certain experience level, and that's why we keep going back to them, or the firms keep going back to them. I think that to do for us is to tell the firms, particularly when we lean on our firms to help us identify the neutrals or the arbitrators and mediators, to lean on them to say, we're interested in trying somebody new, or we're interested in a more diverse pool that you offer us to pick from, and be intentional about it that way.
Yeah, no, that's, first of all, yes, that is the perpetual problem, the chicken and the egg. You know, how do you get the experience? But you know, that is the case for some section of neutrals. Some people, particularly some that are on our call right now, are very seasoned. They have been in the foxhole with others, but perhaps not with you, right? But they would like to get in the foxhole with you. They'd like to be on the law firm's radar that is hiring and making recommendations to you. But because it's very you know, incestual to some extent, that they never get to break out to find other experienced mediators and arbitrators, which is why, and there's been some comments in the chat, and I've mentioned it already, and I will definitely be providing both of you with these lists, but there are other lists that exist that are just of diverse neutrals. Again, the New York City Bar and the New York State Bar and the National Bar Association both have come up with their own lists that are just of very, you know, experience. There's a lot of experience on there, and you can search them by practice area, that are new faces that have been, again, in foxholes with other people, just not yet with you. And it is always a matter of like finding the right case that you're willing to kind of, you know, try somebody new with. And I don't think anyone's asking you to wipe your slate clean, any company to wipe their slate clean and just bring on diversity, because diversity for diversity's sake is useless too, right? That's not the goal. The goal, as you already said, is to develop the best team. And that obviously goes into looking at multiple factors, which we've already discussed here. But all things being equal, right? If you get two people that have the same experience and, you know, been doing this for 30 years and have the subject matter expertise even, you know, maybe it helps to be intentional about giving the nod to the one you haven't tried yet, instead of maybe all the time going to the other one, right?
Yeah. Lauren, I would say to you, you know, you raised the point on sort of networking. And I think it's very critical. The references, especially if somebody has been in the foxhole with another company. I'd like to hear from the general counsel or the litigation chief calling us and saying, hey, I hear you have this dispute. And, you know, this candidate, we've used he or she, and they're excellent. And they know the firms that are involved. They know the lawyers that are involved. So, you know, that actually would make it, you know, help us sort of get comfortable around get other candidates. And I think, you know, if somebody's interested in getting in the foxhole with us, obviously that would actually give us a lot of comfort if they could come to us with the names of other, you know, clients that they've worked with around these situations that could talk to us about that.
I love that as a suggestion. Generally speaking, I have to not push back, but just remark that there's often some phrases, you know, and I'm probably gonna get it wrong, but, you know, people can walk where others have to fly, right? And so it almost has a sense, but I understand what you're saying, right? I can see both sides of the argument, right? That's my mediation skills. I get what you're saying. You know, you need to kind of give me some credibility. If I'm going to go out for you, give me some support so I don't look bad, right? I don't want to lose my case. Help me help you. But there's also the fear of like, you know, are you asking that of everyone that's new? And not you specifically, just generally, is the ask the same for everyone that's new? Or if you have, you know, some other white mediator that has been golfing with his friend and it's like, hey buddy, throw me on that case. You do energy? Yeah, I do energy. And they go to VJ, hey VJ, I got this great guy. You know, are you also asking them, let me see your references, let me talk to your clients? Or is that just something for specifically people that are coming to you like, hey, let's try this diversity initiative. Let's get these new folks. All right, well, run down your resume. Let me get 10 references. You know what I'm saying? Like, is it the same?
No, that's a fair question. And I will tell you that, at least for me, because I moved from New York where I knew a lot of the mediators and stuff that were in my space, I don't know many of the people that I've been working with. So I asked that of everybody because I do want to know what their experience is. And is it just somebody that, you know, like you said, is their golfing buddy that they're putting in front of me because they've done work together and they feed each other work? That's not. And so we are more intentional than that. And I certainly push on the litigators on our team that we are trying to do more than just get me a name and then we're just going to plug them in. It's a challenge with mediators because you also have a counterparty that both sides need to agree upon, but there's no reason why you can't vet that. And we certainly do it at Duke. I know we vet it. We just uniformly go to the same folks.
Yeah. Okay, so there's definitely questions that I would love to get to, but before we turn to the questions, I just want to kind of do an advice for us type of question. So we've been talking about ADR diversity. I know there's a question that we're going to get to about why it's taking so long to move the needle on this, but how can we change this? Let's start today with people that are decision makers, that are members of organizations that are comprised of other people that are similarly situated to both of you, whose ears you have, whose ears potentially we can get to bring this issue to the table, because for a very long time, litigation and outside counsel has been front and foremost, front and center. People take clauses in their corporations sign promises. I'm going to make sure I consider or require X amount of diversity in my legal staff. That's pretty well ingrained, I think, in the culture. ADR, while it's not a new concept, seemingly has been under the radar. And even with a very progressive, DEI focused company like Duke Energy, it hasn't been front and center. And not because of intentionality, just because of lack of awareness or lack of realization, perhaps. And so what can we do? The bar associations that are here today, the other associations that we work with, who can we speak to impress upon decision makers like yourselves that being intentional about all members of your legal team, including the arbitrators and the mediators, is equally important, is the needle needs to move in that as well, because again, it all comes back to the intentionality of it all. And so Vijay, let's start with you, and then we can let Kojo have the last word before we take questions.
Well, I know that, for example, JAMS and AAA have DEI riders. There's a JAMS rider. We don't have mandatory mediation provisions in our contracts, but certainly that kind of, putting in a rider like that into contracts is probably useful to companies that do have those kinds of mandatory mediation things. I would say, and I think you and I talked about this a lot, is that there are, I think you've touched on a very good area that we can actually move the needle on ADR, which we have not done. So my thought is that you meaning the NBA, MCCA, and other organizations like Corporate Counsel Women of Color, if they have ADR provisions, you reach out to, or ADR sub-organizations, reach out within them, because those are minority corporate counsel, or ACC is another one, where a lot of our in-house leaders are active in, and especially diverse in-house leaders, like MCCA, there's a lot of general counsels that are very active in that. That's a great area for the NBA and the ADR section to really sort of say, look, how can we get GCs that care and are committed to MCCA and the diversity mission among in-house legal departments, and then see if we can get those kinds of things adopted. I'm thinking even on the way that I run litigation, sort of making it sort of clear that when we engage outside counsel understands at the assignment level that if there's a mediator, we expect to see diverse candidates included in any sort of panel of proposed mediators that come to us. And that's something that they see up front, rather than we wait until it's time for mediation and then submit something. And oftentimes the timing is such that it's moving very rapidly in litigation, and we have mandatory mediations. And so we need to get someone set up. So do we set that expectation early in the assignment of counsel?
I like the idea of the assignment level, because again, harkening back to my litigation experience, it all kind of happens at the beginning. You begin to shape your team all the way. People start, especially with the presumptive ADR states, mediation happening, arbitration happening, part of contract, you know right off the jump, this is where you're going. The earlier, perhaps, it sounds like they can get you names to consider, the better. The more time you can feel comfortable vetting, et cetera. And the more time they can begin to work on putting together lists, because this is not going to be an overnight change, right? This is going to be a little bit of, unfortunately, it's going to be a little bit of the firms becoming comfortable with other names. They can now have, bring them to you. But they're out there, right? It's not like you're looking for a needle in a haystack. We're here. It's just a matter of connecting with the client. And final words from you, Kojo.
Well, I agree with everything VJ said. I do want to emphasize this networking point. I mean, I practice law. I've been in 3 different law firms, and that seemed to be always the best way to get work, right? People getting to know you. Because at the end of the day, if someone is going to make a recommendation, their reputation is on the line too. And they're less likely to recommend somebody they don't know at all, right? And so, again, I hear you, you've got lists, all of that, but the folks on the list, reaching out to the folks who actually make the recommendations, make the choices, reaching out to VJ, reaching out to other general counsels of litigation, other litigators and big corporations, and letting folks know what you were doing. I think that brings names top of mind. So when the next time someone gets a list, they don't just say, oh, okay, good, let's move on. We used this person before. We used that person before. There's always that it's human nature. There's always that comfort level with people you know and people you've done business with before. And always breaking in tends to be a challenge. I'm not saying it's right. I'm just saying that's the way it works. And so to break in, spending some time networking, spending some time connecting with the folks who actually make these choices and decisions, I think could also be helpful.
Okay.
And one more thing, something VJ said prompted this. Yes, and we have actually fired firms or stopped doing business. I don't want to say fire. Stop doing business with firms that did not align with some of our expectations. I remember one particular firm, we asked them for diversity and they didn't even have any women in the team that did the work. And when we pointed it out, their response was, oh, women don't like that kind of law, which true or false, I thought it was very tone deaf to me, and we don't do business with them anymore. And so to the extent that someone will say, well, back to this question of only, white men can be trusted to do these kind of things, and only people that they have worked with can do these kind of things. Yeah, I mean, we put our money where our mouth is, and we hold people accountable. And if we say we're going to do it, we will do it.
Okay, well, before we head to the chat, I just want to personally thank both of you for your willingness to come talk about, what may be not necessarily the most comfortable topic, your candor, and your willingness to change and recognize growth opportunities, because hopefully you guys can be our pioneers, our mouthpieces, and take this to your groups and say, here's an area we can all do better in. All right, I'm going to switch over to the questions, and let's see. The first question that just came up to me is from Gail Wright, a very experienced practitioner here with us. Thank you for a thoughtful seminar. Kojo, would you speak a bit more about your role as a leader who requires counsel to actualize diversity? How do you accomplish this?
I'm a firm believer in what gets measured gets done. And that's why we set up all these goals. And we tell outside counsel what our expectations are, and we track what they're actually doing. So every month, our leadership team gets together, and we get a printout of every penny that's been billed and paid, and who it went to. And it's broken out, and we ask the firm attorneys working on the matters to self-identify. And so we're able to track how much money is being charged by people of color, how much money is being charged by LGBTQ attorneys, how much money is being charged by women. And we've got a certain, expectation or target, as we've discussed before. So we know how firms are progressing in that direction. We do sit downs with each one of our relationship firms, and our team goes over these reports with them and their performance, the commitments they've made, and how they're tracking, how they're keeping up. So, we're very intentional on that front in terms of the goal setting, the tracking, the measurement, and so forth. And that's how we ensure they do what they say they're going to do.
Thank you. Another question from Alfreda Kenny, also another seasoned mediator and arbitrator. How do you monitor outside counsel regarding the selection of diverse neutrals? What is your process? So to the extent you haven't already spoken about that, if there's something else you'd like to add to that question.
I'll let Vijay answer that one.
Yeah, I don't think we currently monitor per se how we select. Are we keeping diverse mediators and mediators primarily, and neutrals, I would say. What we do is that no mediator is selected or no neutral is selected on any litigated matter without somebody on my team approving it. The attorney who is managing the team would be consulted with. So there is how we monitor sort of, who we engage. And that's where the opportunity is to make sure that we are driving that and ensuring that we're getting recommendations that are diverse. So we can actually look at the credentials of everyone who's being submitted to us as proposed neutrals.
Okay, thank you. Somebody has also asked, does Duke maintain a list of neutrals? And if so, how does one apply to be placed on them?
The answer to that is yes. We do maintain that. It's kept within litigation, although it's shared pretty broadly with other groups that might need the use of neutrals. If you want to have your name added to that, please reach out to me. My paralegal actually maintains that.
There you have it, a direct invitation, networking for you 20 people on here. This is the reason why you showed up, right?
Mm-hmm.
All right.
And
So
he already told everyone he's biased in favor of New Yorkers. So
that's true. Come on, we have a real connection here.
There you go.
And we have the $1 million question, which may be tough to answer. But if you maybe take a shot at it. Why is it taking so long to diversify ADR? Is it because I'm not the panelist. You both are. Do you have any thoughts as to why it's taking so long to diversify ADR? We've spoken a little bit about difficult points of entry. I think Kojo, kind of touched upon that in terms of difficulty to get the experience, and people want the experience. And so perhaps that's a reason. But any other reasons why? And then the follow-up is that this person asks because she worked for a well-known white female arbitrator 15 years ago when she was a law student. And that arbitrator told her then about the lack of diversity in ADR. And here we are in 2022, arguably with not much progress being made.
yeah, I do not know the answers to that. I would ask the same of the legal profession. I think we're one of the least diverse professions in America. Why is it taking so long? I don't know the answer to that, but we certainly trying to change it. In a couple of weeks, I'm actually Charlotte, Mecklenburg County, which is the county I live in North Carolina. The Bar Association has a diversity program where we try to attract them as young as middle schoolers and high schoolers and try to get them to go to law school. And we have our annual conference on potential people who might be interested in going to law school. And I'm going to speak to that group. How many will end up going to law school? I don't know, but I feel like we need to try, and let people know this is an opportunity. This is an option for you. You don't all have to be doctors. You don't all have to be engineers. There's a life in the legal world. And that's one of the ways we're trying to diversify the legal profession in general. In terms of ADR, I frankly don't know. And as you know from our conversation today, it's really not been an area of focus as much for us because, again, I mean, broadly speaking, I viewed it more as a neutrals world, right? Judges, how do you pick judges kind of conversation more than picking a team. And maybe I'm a little myopic in that view, and I will re-examine my views. That's one of the actually D&I commitments I've made. If you go to the, I don't know if you're all familiar with the LCLD organization, Legal Counsel and Legal Diversity. I have a pledge on their website where I think my number one pledge is I'll be open-minded to learn in this space. So I've learned a lot today, and I intend to continue learning, and to the extent that I can add to the diversification of the ADR space, I will do it.
We welcome, we need all the allies we can get. All right, I think there's time for one last question. And this one is, are your ADR cases tracked as to which ones are, quote, bet the firm cases versus not? Are they tracked by type, labor, insurance, personal injury, and corresponding assignments as to whether diverse neutrals are used? I let you answer. I think you indicated that you don't track which,
Well,
but go ahead.
yeah, we do certainly track. Vijay pointed out we have some in the labor and employment space. So that group certainly tracks what ADR cases they have. Vijay and his team will track what ADR cases and mediations, including mediations that we have in the litigation space. So in terms of tracking them, we absolutely do. Do we track the ethnicity and diversity of neutrals? I don't think we do at this point. And maybe we should.
Yeah, I agree with that fully. We certainly, on sort of bet the company versus run-of-the-mill litigation, absolutely, we track that kind of stuff, and we sort of keep high on our totem pole what kind of cases need to be elevated to certain levels of attention within the company as well. So at that level, track.
Yeah, and I'm not aware that we have any of those that are bet the company type cases.
No.
Typically, those will not go to ADR. And I'm perhaps they're making reference to my use of that term, and that may be a little out of context there. My point there was in picking counsel, legal counsel, if I were doing a huge merger and acquisition, for example. And it's not just in litigation space. How do I evaluate which law firm I decide to work with? That was the context in which I was using that phrase.
Okay, well, I again thank you, gentlemen, so much for your time. I know you're both very busy, and your commitment to this issue, to generating change. I look forward to continuing our discussions at some point, checking back in and reporting back to the ADR section and all of our co-sponsoring organizations about the strides that you've made and where you stand, in a year or maybe even less than that. But I will just again thank you very much for joining us. Thank you, all of your attendees, for your attention and your great questions. And we look forward to some further events with our section. So again, thank you very much.
Thank you for the opportunity. Thank you, Lauren.
Very welcome.
Take care.
Take care.